My name is Silvia Díez. I am a lecturer in administrative law at the Universidad Autónoma de Madrid and contributor of that university's Instituto de Derecho Local, Local Law Institute. I am very pleased to be involved in UDITE's Sharing Knowledge initiative. During the following minutes, I will present the main ideas that explain European regulations on public procurement by local authorities. By public procurement, we refer to the procedures by which local authorities award contracts for the supply of public goods, public services, and public works in order to meet the needs of the public concerned. I will focus on this dissertation for more main guidelines. First of all, we will analyze the process of the Europeanization of the regulations on public procurement in Europe. Secondly, we will focus on the sources of the law in this matter and the scope left for the action of bylaws and local regulations. In the third place, I will briefly explain the procedures for the award of public contracts, and last, I will mention the existing review procedures applicable to decisions in European public contract award procedures. Firstly, we will focus on the Europeanization of the regulations on public procurement. We will analyze the causes of the gradual extension of European law over public contracts, in this case, those of local governments. Civil law in continental Europe historically contained rules regulating public contracts. These rules can be arranged in two different models: the French model and the Germanic model. In the Germanic model, there were provisions concerning the awarding of contracts by public bodies. These provisions regulated the internal organization of the procedures and could hardly be considered as law, having no effects on third parties. Beyond these internal regulations, it was the private law that dealt with the performance of contracts, just as in private contracts. In opposition to this Germanic tradition, which includes countries such as Austria, Italy, and Germany, we find the French model, including countries such as Spain. In this case, there were laws concerning not only the award, but also the performance of public contracts, so that these were regulated specifically by public law and not by private law. Therefore, a new conception was created that from the public contract, in opposition to the private contract, which regulated relations between individuals. This new conception was to become an important milestone in the creation of administrative law. The European Union was to introduce a drastic change in this setting. Starting the 70s, the institutions of the Union became aware of the importance of public procurement in general, and that of local governments in particular. Government procurement represents more than 15% of the European Union's GDP, depending on economic cycles. This economic activity, this public presence in the market, deserved as an answer from European institutions. And so it is that, since the 70s, the European Union adopted a series of directives focused on harmonizing the procurement of public bodies in member states. The adoption of such directives during the following years has grown into a full body of law for public contracts. Two main distinctive features can be outlined in these new public contracts European law. First, the importance of the development of the internal market. We must bear in mind that the competency on the European Union over this matter is based on the development of the internal market. This is precisely the main objective of European regulations, and the main reason why they focused on ensuring the competition among economic operators. This is the main concern. In opposition to law in member states that is focused on the performance of contracts and on the nature of its law, whether public or private, the only concern in European law is that the contract be awarded to the most economically advantageous tender, and thus to ensure the competition between operators and to guarantee the selection of the best among them. Because of this, it's impossible to find a similar conception of public contracts in states not influenced by the traditional French system. In Germany, we find the expression Vergabe, referring to the law of the awarding of contracts. In English, we use the expression public procurement, referring to a similar conception, restricted to the awarding of contracts. So, in these countries, what really matters is the phase preceding the contract, and not whatever happens to the public body and the contractor from then onwards, with some details as we'll see later on. Please bear in mind that, along with these concerned over the competition between economic operators, European contract law is only partial, meaning to say that it doesn't regulate all contracts to be concluded by public bodies of the member states, but only a small part. It only regulates those contracts to be concluded by certain entities and for certain issues of public procurement, such as works, supplies and services, and only as long as their value exceeds important economic thresholds. These economic thresholds differ depending on the contracting bodies. The thresholds are greater in the case of local governments, so that the complexity of the procedures is less when referring to such contracts of public local bodies. However, being these thresholds set at 5 million euros for public works and at 200,000 euros for supplies and services, local governments are often subject to highly complex rules in order to select the contractors, providers, or services suppliers. Because the European regulation is partial, meaning incomplete, certain problems have come to light in member states. Please keep in mind that only a part of national law is subject to community regulations. The rest, not in all cases, is ruled only by the principles of European contract law, as a means to ensure that the four European freedoms are enjoyed. This has led to the splitting in two of national contract law in certain countries, such as Spain or Germany, so that depending on the contracting body, the type of contract, and its value, the rules that apply will be more or less exhaustive and complex. How does this affect local government? Because of their small size, the regulations to be applied by local bodies will often be significantly simpler, so that they will benefit from much easier awarding procedures. Where this is not the case, complex local authorities with a high degree of managerial competence will be subject to the strict and difficult rules of community law. After analyzing the Europeanization of public procurement, we are now going to examine the sources of European public contract law. Without forgetting the founding treaties, the two main sources are, on one hand, the directives and, on the other, the case law of the Court of Justice of the European Communities. As we said before, the directives are the core instrument to ensure the Europeanization of public contract law. There are two types: public procurement directives in the strict sense, which are aimed at regulating the award of contracts, the selection of contracts, providers and suppliers. At present, there are directives 2004/17 and 2004/18, both currently undergoing a reform process. Along with the directives that regulate the awarding procedures, there are others, known as remedies directives, adopted to ensure compliance with the first. During the late 80s and the early 90s, European institutions were aware of the difficulties for member states to comply with public contract regulations, so it was decided to adopt new directives, which were to be called remedy directives. These so-called remedy directives, especially directives 89/665 and Directive 92/13, aim to ensure that tenderers, that is, economic operators in the internal market, may require the compliance of procedures with public contract law. These two directives have been reformed in 2007 by Directive 2007/66, which has further strengthened these enforcement mechanisms. Both the awarding procedures provided by the first directives and the appeals procedures will be explained later on. Alongside with these directives, the other main source of public contract law is the case law of the Court of Justice of the European Communities. During the period under review, the Court of Justice has produced a vast jurisprudence aimed at guaranteeing the principles of the internal market in public contracting. Public contracting by local bodies is a situation that has been subject to numerous judgments by the European Court of Justice, and many of them are nowadays baseline leading cases in public procurement. Public contract law has been completed through these court decisions. In fact, many court decisions become positive law through directives, such as in the ones currently under reform. Member state law is below the level of European law and in second rank of the hierarchy of rules. Here, there are two possibilities. Either state members decide to transpose European directives into national law and, for the rest, continue applying their national rules, or state members decide to fully adopt the European public contract law to the full extent, thus creating an only body of rules over this matter. In Spain and in Germany, it is the dual system that has been adopted. This system generates a great degree of legal uncertainty for economic operators, mainly because the rules change greatly depending on the situation. Other countries, such as Austria, Sweden, Poland, and other Eastern countries, have adopted the model of unified regulation where European rules are applied to contracts that needn't be within the scope of the directives. Among the Union's neighbors, European rules are usually transposed through norms with the status of a law, and this task is taken over by the states. In both federal and decentralized states, such as Spain, this is accomplished by the federation or by the central state. Other public bodies, insofar as their autonomy is to be safeguarded, ought to be vested with a certain legislative competency over this matter. However, European regulations are exhaustive, so there is little room left for regional or local regulations. The margin left for local government rules over public contracting will be depend on national law, but clearly they must focus on internal organization and self-regulation under the complex scope of European and national law.